It says, what is the Royal Proclamation? The Royal Proclamation is a document that sets out guidelines for European settlement of Aboriginal territories in what is now North America. The Royal Proclamation was initially issued by King George III in 1763 to officially claim British territory in North America after Britain won the 7 Years' War. In the Royal Proclamation, ownership over North America is issued to King George. However, the Royal Proclamation explicitly states that Aboriginal title has existed and continue to exist, and that all land will be considered Aboriginal land until ceded by treaty. It says, the proclamation forbade settlers from claiming land from the Aboriginal occupants unless it has been first bought by the Crown and then sold to the settlers. It says the Royal Proclamation further sets out that only the Crown can buy land from First Nations. So that's interesting. So basically what it was saying is that this particular king, King George, he made this proclamation and he was trying to claim land in North America, but he said that there is Aboriginal title that the Indian nations have, and that only the British Crown can buy land and not the settlers. Only if they were to have bought it from the British Crown. Anyways, it says, the Royal Proclamation further sets out that only the Crown can buy land from the First Nations. Most indigenous and legal scholars recognize the Royal Proclamation as an important first step towards the recognition of existing Aboriginal rights and title. It says, including the right of self-determination. In this regard, the Royal Proclamation is sometimes called the Indian Magna Carta. The Royal Proclamation set a foundation for the process of establishing treaties. For example, treaty making typically involved the presence of both parties, the First Nation and the government, and for there to be some form of consent between the two, and for the First Nation to be compensated for any lands or resources taken. However, the Royal Proclamation was designed and written by British colonists without Aboriginal input and clearly establishes a monopoly over Aboriginal lands by the British Crown. Is the Royal Proclamation still valid? Some argue that the Royal Proclamation is still valid in Canada since no law has overruled it. The Royal Proclamation is enshrined in Section 25 of the Constitution Act. This section of the Charter of Rights and Freedoms guarantees that nothing can terminate or diminish the Aboriginal rights outlined in the proclamation. The Royal Proclamation also applied to the United States. However, American independence from Great Britain after the Revolutionary War rendered it no longer applicable. The United States, however, eventually created its own similar law in the Indian Intercourse Acts. Despite arguments that the proclamation is still valid, Aboriginal peoples continually have had to prove their existing title to the land through legal disputes. In the British Columbia, in particular, this issue has been the prime concern amongst Aboriginal groups. The vast majority of the province has never been ceded by its Aboriginal peoples, resulting in the argument that non-Aboriginal settlement in British Columbia is on stolen land. The province of British Columbia has maintained that the Royal Proclamation does not apply to BC since it had not been settled by the British when the proclamation was issued in 1763. This perspective is greatly disputed amongst government officials, academics, and the public, some who claim the proclamation would have applied to BC when British sovereignty was established in the province. What does the Royal Proclamation say? The following is an excerpt from the Royal Proclamation of 1763 that deals specifically with Aboriginal peoples. It says, "And whereas it is just and reasonable and essential to our interests and the security of our colonies that the several nations or tribes of Indians with whom we are connected and who live under our protection should not be molested or disturbed in the possession of such parts of our dominions and territories as not having been ceded to or purchased by us are reserved to them or any of them as their hunting grounds. We do therefore, with the advice of our Privy Council, declare it to be our royal will and pleasure that no governor or commander-in-chief in any of our colonies of Quebec, East Florida, West Florida, do presume upon any pretense whatever to grant warrants of survey or pass any patents for lands beyond the bounds of their respective governments, as described in their commissions, as also that no governor or commander-in-chief in any of our colonies or plantations in America do presume for the present and until further pleasure be known to grant warrants of survey or pass patents for any land beyond the heads of sources of any of the rivers which fall into the Atlantic Ocean from the west and northwest, or upon any lands whatever which not having had ceded to or purchased by us as far mentioned are reserved to the Indians or any of them. And we do further declare it to be our royal will and pleasure for the present as forementioned to reserve under our sovereignty, protection, dominion for the use of the said Indians all the lands and territories not included within the limits of our said three new governments or within the limits of the territory granted to the Hudson Bay Company, as also all lands and treaties lying to the westward of the sources of the rivers which shall fall into the sea from the west and northwest as afore said. And we do hereby strictly forbid, on pain of our displeasure, all our loving subjects from making any purchases or settlements whatever, and taking possession of any of the lands above reserve without our especial leave and license for that purpose first obtained." So basically what it sounds like is that the subjects were, the settlers were the Europeans who were encroaching on Indian land, basically. And he was explicitly telling them that, look, you cannot buy any land because we have an agreement with these Indian nations, and if they don't sell us the land, therefore it's theirs, so you don't have the right to it. And it says, "And we do further strictly enjoin and require all persons, whatever, who have either willfully or inadvertently seated themselves upon any lands within the countries above described, or upon any other lands which not have been ceded or purchased by us, are still reserved to the said Indians as foresaid, wherewith to remove themselves from such settlements. And whereas great frauds and abuses have been committed in purchasing lands of the Indians, to the great prejudice of our interests." So to me, basically what that sounds like is that a lot of people who were subjects of the British Crown, who came over there as colonists, he said that it was a lot of fraud going on, and that they were trying to claim land that was not purchased by the British Crown and was not underneath an agreement. That's what it sounds like. Let's see what else it says. "To the great prejudice of our interests and to the great dissatisfaction of the said Indians, in order therefore to prevent such irregularity regularities for the future, and to the end that the Indians may be convinced of our justice and determined resolution to remove all reasonable cause of discontent, we do, with the advice of our Privy Council, strictly enjoin and require, and no private person do presume to make any purchase from the said Indians of any lands reserved to the said Indians within those parts of our colonies where we have thought proper to allow settlement, but that if at any time any of the said Indians should be inclined to dispose of the said lands, the same shall be purchased only for us in our name at some public meeting or assembly of the said Indians to be held, that the purpose of the governor or commander-in-chief of a colony respectively within which they shall lie, and in case they shall lie within the limits of a proprietary government, they shall be purchased only for the use and in the name of the proprietaries, conformable to such directions and instructions they shall think proper to give that purpose. And we do, by the advice of our Privy Council, declare and enjoy that the trade with the said Indians shall be free and open to all of our subjects. So basically the king was giving his subjects permission to trade with the Indians with the advice of his Privy Council. It says, whatever provided that every person shall incline to trade with the said Indians to do take out a license for carrying on such trade from the governor or the commander-in-chief of any of our colonies, respectively, where such person shall reside, and also give security to observe such regulations as we shall, at the time, think fit, by ourselves or by our commissionaries to be appointed for this purpose, to direct and appoint for the benefit of the said trade. And we do hereby authorize, enjoin, and require the governors and commanders-in-chief of all of our colonies respectively, as well those under our immediate government as those under the government and direction of proprietaries, to grant such licenses without fee or reward, taking a special care to insert within a condition that such license should be void and the treaty forfeited, in case the person to whom the same is granted shall refuse or neglect to observe such regulations as we shall think proper to prescribe as foresaid. And we do further expressly conjoin and require all officers, whatever, as well as military, of those employed in the management direction of Indian affairs within the territories reserved aforesaid for the use of the said Indians, to seize and apprehend all persons whatever who standing charged with treason, misprisons of treason, murders, and other felonies or misdemeanors shall fly from justice and take refuge in said territory, and send them under a proper guard to the colony where the crime was committed of which they stand accused, in order to take their trial for the same, given at our court at St. James, the 7th day of October, 1763, in the 3rd year of our reign. God save the king. Okay, so that's the end of the royal proclamation. So basically, they're saying that this still applies to Canada because we know they're still underneath the crown, underneath the British crown. But because of the Revolutionary War that took place in the United States is no longer underneath the British crown. So they're saying that this royal proclamation doesn't apply to the United States, but that the United States came up with their own version, which is the Indian Intercourse Acts. Okay, so this is what they was talking about. It says an act to regulate trade and intercourse with the Indian tribes and to preserve peace on the frontiers. The Library of Congress. It says the 23rd Congress, Session 1. It says 1834. It says here, be it enacted by the Senate and the House of Representatives of the United States of America and Congress assembled, that all of the part of the United States west of the Mississippi and not within the states of Missouri and Louisiana or the territory of Arkansas, and also that part of the United States east of the Mississippi River and not within any state to which the Indian title has not been extinguished for the purpose of this act, be taken and deemed to be Indian country. Section 2. And be it further enacted that no person shall be permitted to trade with any of the Indians in the Indian country without a license therefor from a superintendent of Indian affairs or Indian agent or sub-agent, which license shall be issued for a term not extending 2 years for the tribes east of the Mississippi and not extending 3 years for the tribes west of the river. And the person applying for such license shall give bond in a penal sum not extending $5,000 with one or more sureties to be approved by the person issuing the same, condition that such person will faithfully observe all of the laws and regulations made for the government of trade and intercourse within the Indian tribes, and in no respect violate the same. The superintendent of the district shall have power to revoke and cancel the same whenever the person's license shall, in his opinion, have transgressed any of the laws or regulations provided for the government of trade and intercourse with the Indian tribes, or that will be improper to permit him to remain in the Indian country, and no trade with the said tribe shall be carried on within their boundary except at certain suitable and convenient places to be designated from time to time by the superintendents, agents, or sub-agents, and to be inserted in the license, and it shall be a duty of the person granting or provoking such licenses therewith to report the same to the Commissioner of Indian Affairs. So to me, it seems like basically what they're saying is that these subjects, these citizens of the United States, that they had to get a license from a commissioner that was under, I guess, the Bureau of Indian Affairs in order for them to do trades with our people. That's what it sounds like. So I'm going to have the link to this below as well. Okay, so now we're going to dive into the difference between Indian country and reservation, because as you saw in the other part of the video, it was talking about how subjects of the United States, how they needed a license from the Bureau of Indian Affairs by a superintendent or some other type of official, an agent, an Indian agent, or an Indian sub-agent in order for them to trade with us, do commerce with us, right? Which is, what our ancestors, when they were selling furs and selling, gator skins and, food and tobacco and, hemp and other things that our ancestors were selling, that the Europeans, in order for them to buy these goods from us and to be able to sell them with their people, they had to have a license. And that act was called the Indian Intercourse Act, okay? And they had mentioned, Indian country. So we're going to listen to what Aboriginal Mac, what he has to say about what that is.
More asked me to give you more definitions for kinship.
No, thank you, Alexa.
Okay.
This video is about the difference between Indian reservation and Indian country. I've talked about this video about a year ago. Well, I've done a video on this topic about a year ago. But let's go even further to explaining what is a Indian reservation. So we're going to start here. If you guys can see my cursor, we're going to start here. And it's very important you guys know the difference, because there are other YouTube channels who have discussions with people who live on reservations, and not only does the YouTube personality give out false information, but the person who's living on a reservation who is also confused is given the misconception of what a reservation is. So, Indian reservation, a part of public domain. Let's not go any further as of right now. Let's read that again. Indian reservation, a part of public domain. So that's letting you know it's not private. It's not owned by the people. Let's continue on. Set aside by proper authority for use. So as I was saying, it does not belong to an actual people because the person that's in charge has set that aside for someone. Now let's continue to read as to who it's for. For use and occupation of tribe or tribes of Indians. Now, this last sentence of tribe or tribe of Indians can mean two things. It can mean that it's a specific or individual tribe or tribes of Indians, or it can read like this. It can read set aside by proper authority for use and occupation of tribe. Of tribe, and you see it does not have Indian at the end of it. So it can mean any type of tribe, meaning foreign tribe or tribes of Indians, since it's public domain. Right? This is reading comprehension. So now let's go up and let's read the definition of Indian country. Indian country, as the term is used in the federal statutes, is a country to which the Indians retained the right of use and occupancy involving, under certain restrictions, freedom of action and of enjoyment in their capacity as a distinct people, and cease to be such when their title is extinguished. Ceases to be such when their title is extinguished. Meaning when you give up your identity, when you don't know who you are, then you're not an Indian anymore. Although we know if you still have Indian blood, then you are an Indian. But if you do not know who you are, then you cannot have the title Indian. But we're gonna scroll further down because this is important. This bottom portion, it says this term does not necessarily import territory owned and occupied by Indians. So once again, that goes back to when your title is extinguished because you don't know who you are, then other people can live in your land. But we're going to continue to read. But it means all those portions of the United States designated by this name in the legislation of Congress. So I hope you learned something from this, because there's a difference between Indian country and Indian reservations, and the people who lives on reservations. Now this is going to open up a can of worms, but there's a difference between a corporation tribe or a corporate tribe and the actual people, the races of Indians. Now let me show you. I've showed this plenty of times, man.
Okay, so Indigenous Foundations Arts, and this is British Columbia. And on here on this website, they're talking about Aboriginal title, and they have a link to the Royal Proclamation of 1763. They have a link to the UN Declaration of Rights of Indigenous People, and what it says here, it says Aboriginal title. Aboriginal title refers to the inherent Aboriginal right to land or territory. The Canadian legal system recognizes Aboriginal title as a sui generis or unique collective right to the use of and jurisdiction over a group's ancestral territory. This right is not granted from an external source, but it is a result of Aboriginal people's own occupation of and relationship with their home territories as well as their ongoing social structures and political and legal systems. As such, Aboriginal title and rights are separate from rights afforded to non-Aboriginal Canadian citizens under Canadian common law. So that's pause right there. So basically what they're saying is that Aboriginal people, the American Indians, they have a right to their lands and their territories because of the fact that they have, a occupation. They have a history of occupying that land over years and years and years, and they have a cultural connection to it. So with that being said, that means that you have right over that land, a higher right over it than a person that is a non-Aboriginal person, meaning, a foreigner. It says, over time, various court decisions have contributed to this definition of title, along with defining Aboriginal title in more precise terms. These court decisions have further set parameters so how the Crown may justifiably infringe upon Aboriginal title. Some Aboriginal people do not agree with these definitions, as they consider them to limit the scope of Aboriginal title, making it easier to extinguish. And we know extinguish is to, get rid of it. It says the Union of the British Columbian Indian Chiefs claims that there remains a significant difference between what Indigenous people see as being our original title to the land and its resources and the Canadian legal notion of Aboriginal title. Okay, so that's that.